All right, this is the case of Rebecca Tilford, formerly known as Rebecca Canales, as personal representative of the estate of Bernie Sawyer Canales Tilford, deceased, versus Three Rivers Health Systems, Inc., Ruth Alice Tatera, CNM, and Seema Satish Salvi, MD, 191030NH. And we have Mr. Laparle here on behalf of the plaintiff, and we have Mr. Busher here on behalf of the defendant. And it is plaintiff's motion to file a second amended complaint. All right, and Mr. Laparle has filed his motion and Mr. Busher has filed an objection. And here we are. So go ahead, Mr. Laparle.
Thank you, Your Honor. May it please the court. This is our motion to amend the complaint. I know the court is familiar with this case. This case involves the death of an infant who was born at Three Rivers Hospital. There was some difficulty with the resuscitation. She was transferred from Three Rivers to the University of Michigan and died shortly thereafter of complications related to brain damage. We recently took the deposition of Dr. Puckett, and Dr. Puckett is an obstetrician gynecologist who was called in to deliver this baby after it was recognized that the baby was in trouble and needed to be delivered ASAP. And Dr. Puckett, we didn't sue Dr. Puckett initially. We took her deposition, and the labor and delivery was managed by midwife Tatara. And Dr. Puckett testified that pursuant to the hospital procedure and policy and the practice, she was the supervising physician over the midwife. And a midwife has certain limitations on what he or she can do. Midwife cannot do a C-section. And if there's an emergency, as there was in this case, they have to call in an obstetrician or gynecologist or a physician. They're not licensed to do that in Michigan, and she didn't have privileges to deliver this baby if there was an emergency. So based on the testimony of Dr. Puckett, that she was the supervising doctor over nurse midwife Tatara. We didn't know that before we took the deposition. We had to find that out at the deposition. We sent that to our obstetrical expert who said, well, if she's the supervising physician, then she needs to be aware of what's going on and should have asked some more questions and should have been more involved in this. And certainly the hospital would have some exposure based on that because of the supervisory responsibility. We didn't know that before we took the deposition. It was confirmed at the deposition. So we're asking that we simply be allowed to amend the complaint. There's time left on the statute of limitations. The parties have been working cooperatively. We've done a number of depositions. We've got more depositions scheduled. There's been some talk about potentially trying to resolve this case. I don't know whether that's going to happen or not, but this won't affect the scheduling at all. We'll just continue on. We haven't started with experts yet, so there would be no prejudice to the defendants. And in order to make sure that we have all the proper parties here and all the players, it's necessary to amend the complaint. I have an expert that is prepared to sign an affidavit. He is going on vacation tomorrow, or maybe even today. He's going to be gone a week. So it may take me a week or so to get him to sign off on the affidavit of merit, but I can have this filed quickly. It won't affect, as I said, anything that we're doing in this case. And to not allow the amendment would not be fair to this family. So that's my argument. I don't have anything else unless the court has some questions for me. And I guess I want to, as we proceeded with this case, we've had to do some discovery, and we keep learning things that were only possible of really nailing down through depositions. We amended the complaint once to add claims against a pediatrician who was involved with a resuscitation. And the court heard argument and recognized at that time that that was the appropriate thing to do. That was not too long ago. It's essentially the same situation here, as we're building blocks and learning things through discovery, our experts are saying, okay, this is, now that I have this information, now that I know this, I can sign on to the case. Before we took the deposition of Dr. Puckett, the expert said, I don't know what Dr. Puckett's role was. I know she came in at the last minute and delivered the baby, and there's nothing wrong with that. But if the testimony shows that she had some supervisory responsibility, then, you know, arguably, depending upon what she says at her deposition, I would be critical of her and the institution. So that's the argument right there. There's no prejudice, and we can just get this thing filed and move on and get the case ready for trial. Or if not, if it doesn't go to trial, we'll work on getting it settled.
Okay. I do have some questions. There's, in medical malpractice cases, there's already a built-in waiting period where you have to investigate the claim and speak to your experts and get affidavits of merit. And then you said you've already started discovery. So if you're going to bring in Dr. Puckett, that necessitates the retaking of all discovery and depositions that have already taken place. And you said that you hadn't taken any experts yet, but you took the testimony of Dr. Puckett, who is an expert, but maybe also a fact witness. But did you mean that, you know, just the consulting experts, you haven't done their discovery yet? When you said that you hadn't taken any experts' depositions yet?
Correct, Your Honor. We haven't taken any consulting experts, the retained experts. We've taken depositions of fact witnesses in this case. We've done depositions of some nurses. We've done some depositions of the midwife and Dr. Puckett. We have more fact witnesses scheduled. And Dr. Puckett was included in the notice of intent because her name appeared, but based on just the record, my expert said, you know, based on just what I'm seeing in the record, if she was called in at the last minute, I can't sign an affidavit. I'm not going to sign an affidavit for you saying that she committed malpractice. On the other hand, if you take her deposition and it turns out that she had some supervisory responsibility, we didn't know. There's nothing in the record to indicate when she was contacted or how she was contacted. So until we took that deposition and found out what she had to say, there was no basis for the claim. My expert couldn't sign on to it. Now that we have the deposition, I immediately sent it to him, and he said, okay, now I have this information, and based on her testimony, I would be critical of her, but I had no way of knowing that, and I wasn't going to sign an affidavit, and I'm not going to sue it. And I feel a responsibility. Obviously, I need an expert to do it, but I'm not going to sue someone until I have the facts to support it. And that's why we take depositions, and that's why we do discovery.
Okay, so this is, you guys are the experts in the field of medical malpractice. And I have maybe one case every 10 years of medical malpractice. So I don't, and then I have to bone up on it. So when you said that a midwife is very limited in her role and that she has to work under the supervision of a gynecologist or an obstetrician, I would think that if you saw that she was doing, a midwife was practicing, you'd know that somebody in the hospital must have been supervising her. Or is it just that in this circumstance, she was being supervised, but normally she would have to call somebody in, or he would have to call somebody in if there was a problem outside their scope of expertise? Do you understand what I'm saying?
I do, Your Honor.
Not every case involving a midwife, there has to be a gynecologist or an obstetrician supervising.
No, in the majority of cases, the midwife, if there are no complications, the midwife can do everything on his or her own. If there's an emergency that requires a C-section, and I want to be careful what I say here, a midwife is not licensed in Michigan to go into the operating room and do a C-section. They have to bring in a physician to do that. And in this case, we knew that Dr. Puckett was called at the end and came in and delivered the baby and was involved in that aspect of it. What we didn't know is the hospital policy on under what circumstances would a midwife need to be involving an obstetrician? And that's the information that we got. And we didn't know what until we took her deposition, we didn't know what she was going to say about whether she was contacted, when, how much involvement she had, whether she was acknowledging that she was the supervising physician at that time leading up to it, or if there was someone else that had that responsibility. So we had some information, but not all of the information. And my expert said, until you take her deposition and find out exactly what her role was and what she has to say about it, I'm uncomfortable signing an affidavit. So that's the chronology, and that's why we're here right now. I can't read tea leaves and know exactly what people are going to do. I don't have a crystal ball. So until we take depositions and figure out exactly what the various positions are of witnesses and what they're saying, it's somewhat of a moving target. So now this is all complete, and we want to wrap it up and make sure that we've got all of the people that need to be involved. And there's no statute of limitations. I guess I can file a separate action and move to consolidate, but for purposes of efficiency, it makes more sense to do it now, and we've got time to do it. So it would be more prejudicial to the plaintiff to not allow us to do this than it would be to, and I don't see that there's any prejudice at all to the defendants. And if they want to, open discovery up and allow a witness to comment on something that they didn't have a chance to comment on, I wouldn't have any objection to that, but I don't think it's going to change how we proceed in this case.
All right. So that's what I was trying to get at, Mr. Laparle, is that if you have a medical malpractice case involving a midwife, you would look for the supervising physician. That isn't the rule. It's just that if there is a procedure that's needed, somebody comes in. Now, what you found out in this case was this doctor was saying she was acting as the supervising physician, or she was acting in some supervisory area rather than just being brought in to do. Now, was it a C-section or was it just a normal delivery?
It was a C-section.
Okay, because you said for a C-section then delivery. Okay, so I read your brief, Mr. Bush, and I saw that, and that's why I was curious as to why you wouldn't name them automatically if it was expected. And now we have Mr. Laparle's explanation as to why it wasn't, and it's been laid out. And so go ahead.
Yeah, thank you, Your Honor. David,
I can't hear you, Mr. Busher.
How about now?
Yes.
Oh, thank you, Your Honor. Sorry about that. I disagree completely with Mr. Laparle's explanation of the supervision of the midwife and the relationship between the obstetrician and the midwife. The best place to look for that information, I think, is the series of questions that it wasn't Mr. Laparle, it was Mr. McKean, asked to Dr. Puckett in her deposition. I quoted those in my brief here. The question asked was, the state laws and professional guidelines require that nurse midwives be supervised by an attending. Isn't that correct? This is from plaintiff's counsel to Dr. Puckett. After Dr. Puckett then said she wasn't sure what the state guideline were, he followed up by asking, quote, I would hope that nurse midwives were supposed to be supervised by obstetricians. Is that fair? And Dr. Puckett responded, at that time, yes, and even now, yes. Nurse midwives are supervised by physicians. So this is how this works. Midwives can do some tasks independently, but in practice, they are always operating under the supervision of a physician. There's things they can't do. Doing a C-section is one of them, but there's other things, types of medication they can't order. They're always collaborating with a physician in the treatment of patients. How it works at Three Rivers is that there's a midwife on there at all times. And then there's an obstetrician on call 24/7 for consultation and involvement. Dr. Puckett testified in her deposition that she was not contacted or involved in the last few hours of this labor and delivery until right at the end. And she talked about how generally, she's in this supervisory role, but that doesn't mean that she was reviewing any of the information or being contacted during those last few hours. you know, this is just the way that the practice works between a midwife and an obstetrician. And the idea that this information couldn't be known or wasn't known before her deposition, we just completely disagree with. Among other things, Ruth Totaro was deposed 9 months ago. To the extent they were curious about Dr. Puckett's involvement and supervision over Ruth Totara, they could have asked Ruth Totara. They deposed 8 nurses that were involved in or not involved in different parts of the labor and delivery and resuscitation. They also could have asked about that supervisory role, and they didn't. The biggest piece here is that this issue of prejudice. We acknowledge in our brief, there's not much prejudice, for example, to Dr. Selvey to have claims added against Dr. Puckett. And there's only limited prejudice against the hospital for claims added against Dr. Puckett. The hospital's already here for the care provided by the midwives and the nurses. Adding this in-between layer of the obstetrician in the middle, isn't really changing anything about those claims as it relates to the hospital. But as it relates to Dr. Puckett, this is extremely prejudicial. Right? She's not a named defendant in this case. She's not defending the case. She hasn't been involved in litigation decisions for the past 18 months that this case has been going on. She was not consulted about the depositions of the other providers. She just didn't have the opportunity to participate in any way. And so if she's going to be added to the case, we're in a completely different position than we were 6 months ago when they moved to add Dr. Selvey. When they moved to add Dr. Selvey hadn't been deposed. None of the other people involved in the resuscitation had been deposed. There was still the opportunity, even though we still believe it was inappropriate and there was delay in doing that at that time. The key discovery and the key issues about Dr. Selvey's care hadn't yet been addressed. We're in a different place now. We're talking directly about care that they're claiming now is going to be the responsibility of Dr. Puckett. The fact that she's been deposed is really, what we would put as the biggest issue here. I think there's a conflation of the idea that if it's not futile, then it can't be prejudicial, right? Those are different factors. If those were the same thing, we wouldn't have to consider both options. We would just look and say, hey, has the limitations period run? No, okay, it's not prejudicial. That's the factor of futility. Here, what we're looking at is the prejudice to Dr. Puckett. During the deposition, this issue was raised specifically in an objection by my office. When plaintiff's counsel started asking about the standard of care and the obligations direct to Dr. Puckett, the question was, you're obligated under the standard of care to monitor the mother and baby, correct? Here's our objection. She's not even a defendant. Why are you asking about her standard of care? That's not relevant at all, Brian. Are you going to name her? If you file a complaint, and we'll look at it and then present her for her deposition. At that point, plaintiff's counsel did not stop asking questions about Dr. Puckett's standard of care or stop delving into those particular issues. He responded, as I suggested to you earlier, it's not appropriate for you to be talking. And then he continued asking specific questions that would relate to Dr. Puckett's own standard of care and treatment. She didn't have the opportunity before her deposition to know what any claims against her would be. And we can't undo it. We can't go back to a place where claims have been made against her. She's had the opportunity to review the records concerning her own care and treatment. She's had the opportunity to prepare to defend herself and then testify under oath about the facts and the issues involved. It's just impossible to undo that at this point. I know that Your Honor had addressed potentially redoing some of these depositions. Obviously, we'd have to figure out the extent to which that would be necessary. And that would be difficult as to I guess it's 13 depositions now that have been taken. Obviously, the issues that relate to Dr. Puckett are similar to the issues that relate to many of the other defendants. I'm not going to pretend that she's in a completely different place than the other defendants and that the issues that we've already been addressing. We're not going to have to redepose the plaintiff. Dr. Puckett would have the same general interests as the other defendants that we have been representing in this case. But when it gets down to the specific labor and delivery care, I think we're in a completely different position. And, it's something that can't be undone. And even if you accept the argument that this couldn't be known until her deposition, which we disagree with because it was plaintiff's counsel who's bringing up these issues and asking leading questions about them, not the other way around. Even if that was the case, once that became clear, and those questions had been answered, they should have stopped the deposition, filed the complaint, and then taken her deposition with the benefit of those claims being brought against her. We can't do that now. And for that reason, along with the fact that this case has been pending for however long already, we believe this motion to amend should not be granted. Just as one last piece, there is no proposed amendment that's been provided. We provided some authority in our brief focusing on the idea that you actually do need to provide the proposed amended complaint for consideration by the court, right? I don't know, right? I don't have the ability right now to argue about whether the specific claims that they're proposing to be brought are connected to or not. The issues that they're arguing necessitate the addition for these additional claims. You may recall that the motion to bring claims against Dr. Selvey was focused on the involvement of Dr. Selvey, blood gases that Dr. Selvey had reviewed, things of that nature. Well, we didn't have an amended complaint to review at that time either. When they actually filed the amended complaint, they added 3 additional defendants beyond Dr. Selvey. They didn't name them in the caption, but they brought care violation claims against nurses. They added an affidavit of merit against the nurses. So, you know, we don't know what we're dealing with here as far as these claims. In our opinion, no claims would be appropriate against Dr. Puckett at this point. But if Your Honor was going to move in that direction, I just don't know what basis we have to even make the determination right now without the specific claims they're proposing to bring to even be considered here.
Your Honor, may I respond very briefly?
Hold on one second. All right, I've been looking through the court rules trying to find the, we got MCR 2.112, 2.207, other motions. And again, I can't find it. And if either one of you know it, the requirement that the sample of the amended complaint be attached to the motion. Usually it's required, but I can't find where that rule is. So that's what I was looking for.
Yeah. So in my brief, I referenced MCR 2.118A4, which requires that amendments be in writing. And then that doesn't specifically reference amended complaints, but I cited a case where they interpreted that to mean the written amendment needs to be submitted to the court for consideration.
Okay. So 2.118.
Yep.
Except as provided in subrule A1, a party may amend a pleading only by leave of court or by written consent of the adverse party. Leave shall be freely given when justice so requires. Finding that inexcusable delay in requesting an amendment has caused or will cause the adverse party additional expense that would have been unnecessary had the request for amendment been filed earlier, the court may condition the order allowing amendment on the offending parties reimbursing the adverse party for the additional expense, including reasonable attorney fees. Amendments must be filed in writing, dated, and numbered consecutively, and must comply with MCR 2.113. So it doesn't, I mean,
If I can add, I don't think there's any requirement that a proposed amended complaint be included. I've not seen that in the rules. It is sometimes done and sometimes not done. If the court would like us to submit a proposed amended complaint along with an affidavit, we're happy to do that. I didn't want to go through the exercise of doing that and incur the cost of having my expert go through it if the court wasn't going to allow it, but I'm certainly happy to do that. And then I would like to add, Your Honor, although there is some recognition and knowledge among us lay people and certainly our experts that in certain circumstances there is a supervisory role of a physician. In this case, we didn't know the specifics, and until we took the deposition, in fairness to Dr. Puckett, we wanted to find out what her testimony was. Is she the exact? Was she in fact the supervising physician? It could have been someone else early on. We didn't know that, and until we had that information, we weren't able to. At least our expert wasn't able to sign on. Now that he had it. He can sign on to an affidavit, but it would have been unfair to her to make assumptions until we knew exactly what her role was, despite the fact that, yes, in certain circumstances, the midwife does have to be supervised, but the particulars make a big difference. And in this case, it did. And we could file a separate case against her because statute hasn't run and then move to consolidate. But it just seems to me that it makes more sense to amend the complaint. Amendments, as you indicated, are freely granted. Most of the testimony that she gave was fact testimony, and the facts are the facts. And whether she's a party or not a party, that's not going to change. I would hope it wouldn't change her testimony as to what she did, when she did it, and why she did it. That shouldn't make any difference whether she's a defendant or a non-defendant. The facts are the facts. The truth is the truth. So if she's going to tailor her testimony one way if she's a defendant and another way if she's not, that doesn't make any sense. So for all the reasons that we've indicated, and amendments are freely granted, this should be allowed in this case, Your Honor.
So I take it that you have no complaints about her care that she provided. It's only in regards to the supervisory position that she had over the midwife?
Right. And there are, there are already claims against the institution. So it's not, and as Mr. Busher indicated, there's no real prejudice to the hospital or the institution here. And, if she's going to testify one way if she's a defendant and another way if she's a non-defendant, that doesn't make any sense.
It goes, the other way too. I mean, it doesn't make any sense that you're going to add her, take her deposition, and then seek to amend after you've taken her deposition. To say that that's kind of, that's just not. I don't know what you want to call it. I don't want to.
Well, Your Honor, I don't want to be derogatory. We refer to it as gamesmanship, right?
That was the word I was thinking of, but I didn't want to say it out loud.
And you make it.
We were going to add her, Your Honor. We didn't know that at all until she testified. And
okay. Let's get okay. Yeah, obviously, you had some inkling you were going to, because you started asking her standard of care as to what her duty was as the person there. Now, maybe that's because they then found out she was a supervisor or not. And even that line of questioning that Mr. Busher offered, she said she wasn't even aware that there was a standard of care. And then you asked her to give an opinion if she would agree with counsel as to what he said the standard of care was. So I don't know how much value that has. The fact of the matter is the statute hasn't run. They could file a separate complaint against the doctor and then seek to bring it in. I'm to give leave freely. And there is this question that they didn't know until they took her statement. Apparently, none of the other depositions disclosed that there was this supervision being done by Dr. Pluckett to the midwife. None of the nurses said it. The midwife didn't even say it. So until Dr. Pluckett said it, I guess they didn't know.
And Your Honor, I would, if I may interject, they weren't asked. The plaintiff's counsel developed this line of questioning and brought it up and asked leading questions, initiating the conversation about what this supervisory role looked like. It wasn't something Dr. Puckett brought up and they delved into. They said specifically, wouldn't you agree that a midwife is required to be supervised by a physician under Michigan state laws and statutes? And she said, I don't know what the law says. I only know what my practice is. And they followed up and clarified. And she said, well, yeah, of course. That's how this relationship works. Those questions could have been asked in literally 9 previous depositions. One other issue that I just wanted to respond to is that plaintiff's counsel has referenced several times what the prejudice to the plaintiff looks like on this issue. And Your Honor has already referenced the fact that the hospital's already here. The hospital is already vicariously liable for the care by its employee, Ruth Tatara, and these nurses. Adding this layer of the obstetrician in the middle doesn't do anything for plaintiff's case. It's already been disclosed based on initial disclosures and the claims that are made. The claims plaintiff is making are well in excess of policy limits. They're not getting any new policies by adding Dr. Puckett. What it does add to Dr. Puckett that didn't exist previously is this level of personal exposure and defense of her own care. To the extent that we're looking at it, the last piece I would add is that last time they were allowed to amend a complaint, it went well beyond what was discussed in the motion to amend the complaint. And I'm very concerned about what that will look like this time as well.
All right, then I agree with that. So, Mr. Busher, before I grant the request, I'd ask to see the proposed amended complaint. You don't need to attach the affidavit. I mean, it'll be contingent upon getting the affidavit to support it. Is that all right, Mr. Busher, just to see what they're asking to add as far as the amended complaint without the affidavit?
That won't bother me either way, Your Honor. Normally, it's a literal copy and paste of the exact same language in the affidavit and the complaint. Technically, a med-mal complaint is not considered valid without the affidavit. Whatever you'd want to see here, I understand.
You didn't want to have to pay the expert to provide an affidavit if I wasn't going to let him amend. So I want to see the proposed amended complaint and see where that goes. So
understood.
How long do you need that, Mr. LaParle? You don't have to wait a week for your expert now. I mean, how long can you provide that?
I could provide that within 10 days, if that's okay, Your Honor.
Okay. There's no deposition set within the next 10 days, are there?
Not that I'm aware
No,
of.
Your Honor. Actually, there's no further deposition set right now. I think we've
Okay.
been waiting for the resolution of this motion. I would mention there's a witness list due next week. I'm assuming that if this motion is granted, we're going to need, we're certainly going to need a lot more time. You know, once we
It's
get an
gonna
affidavit of
reopen,
merit.
it's gonna reopen discovery.
Right.
I mean,
Well, and
clearly,
discovery is not closed. We have 6 months left. It's just that there will be new witnesses. We'll need to
No,
go
I
find an
understand.
expert and all of that. Okay.
yeah, don't worry about any of that stuff. If I add a new party, then, you know, it starts the ball over from the beginning. So, okay.
Okay.
Thank you, Your Honor.
Is that even a saying? It starts the ball over from the beginning? I don't even think that makes sense, but you know what I meant. It starts the timelines over from the beginning.
Made perfect
I think
sense.
if we understand it, that's all that we need, right?
All right, so get the amended complaint, proposed amended complaint filed, and then we'll take this up again in a couple of weeks. So I'll have Kathy set it for 2 weeks from now, and then you'll have that done. Is 2 weeks too soon? I mean, if you said 10 days, do you want it further out than that?
No, 2 weeks is fine.
Your Honor,
Somewhere
you'll
around
have
2
somebody
weeks.
else here from my office in 2 weeks. I'm having a baby in a week and a half. So that's totally fine. We can have somebody else cover.
Is it your first or second or
Third.
Third. Okay. Wow.
We're about to be outnumbered.
Congratulations.
Thank you.
And okay, so, well, this has been your case from the beginning, right?
Yeah, Kevin Lesbrance and I are both the attorneys on this file, so
Okay.
he's familiar with everything that's going on.
All right, fair enough. Okay, well, we'll set it then, and you take care of your family, and we'll see you back here in a couple of weeks after that then.
All
I
right.
mean, we'll see you in a couple of weeks, Mr. LaParle. We'll see you in a couple of months, probably, Mr. Busher.
All right.
Sounds
All
good.
right. All
Okay.
right, thank you.
Thanks.
Thank you, Your Honor.
Hey,